well said. I will be facilitating the first session. And this session is on individual communications of the UN treaty bodies to advance the human rights of people on the move. This session will include formal requirements, procedural requirements, some challenges, and the added value that this instrument will bring to your cases, to your litigation, as Anna said. At the end, we will have 15 minutes for questions and answers. And as was already said before, if some questions in this session we cannot get to because of the short duration of the session, we may still have a chance to answer them at the end of the second session. And if not, please anyway feel free to send us the questions to any of us in the panel, and we'll do our best to send our answers afterwards. So it is my pleasure to introduce the panelists for the first session. Ana Batalla, whom you already heard, is in charge of urgent actions and petitions. She already introduced her position as well. She has over 15 years of experience in the UN's Human Rights High Commissioner's Office. She has worked in Geneva and also on the ground and in the Office for South America more specifically. Afterwards, we will listen to Rafael Cid, co-founder and director of legal strategy in Centrum, and he focuses on human rights strategic litigation. He is also a professor in the University of Deusto in Bilbao in Spain, where he also teaches human rights strategic litigation. Very quickly, something about Gentium, his organization. It seeks to promote the use of law to effectively protect the rights of underprivileged and people who are traditionally ignored. Without further ado, I want to leave you with Ana in her expert hands, and I'll be sharing the screen as well with a presentation that she prepared. So I will turn off my camera and microphone, and Ana, over to you.
Muchísimas gracias, Silvia.
Thank you very much, Sylvia.
La presentación solo un segundito.
I'll just wait for the presentation to show up on the screen. Okay, this first part of the presentation will focus more on the practical aspects, the procedural aspects. As I said, in the petition section, we receive all claims, individual claims submitted to any of the treaty bodies, and we monitor them from the moment they are received until the last stage in the process. We offer support to the committees in their adoption and preparation of projects for resolutions or decisions. What we cannot do is offer legal advice. We cannot help to improve individual claims, for instance, or offer any advice related to them, but we can share information about jurisprudence, about the process, and afterwards organizations can use this information to decide whether or not they want to submit a claim to any of the UN treaty bodies. Next slide, please, Sylvia. The UN system supplements existing regional systems, especially in Latin America, the Inter-American system, the Commission, and the Court that I believe many of you are familiar with. There's also the European system and the African system. As we know, jurisprudence on the same issues are not always the same for different regions. Sometimes it is, but solutions or resolutions can vary from place to place. And sometimes it is possible to submit the same case to one system and then to another. Next slide, please. Also, to give you an understanding of where this fits in the institutional framework within the UN, The
están en lo que llamamos
treaty
mecanismos
bodies
convencionales, que
are
son basados
within
en
the
tratados
so-called
internacionales y por
conventional
tanto tienen una
mechanisms,
fuerza
meaning
jurídica muy
international treaties.
importante,
So they have a
porque
very
los
important
tratados tienen fuerza
legal
vinculante
force
cuando
because
los
they are
ratifican
legally binding.
o
Treaties
acceden a
are
ellos los
legally
estados,
binding. When a
pero
state
también
decides to sign or
conocerán
join a
seguramente que
treaty,
existen
it becomes legally
los
binding.
mecanismos
But as you know,
extraconvencionales
there are
como los
also
mecanismos del
so-called
Consejo y en particular
extra-conventional
los
mechanisms,
mecanismos
such as
de
the
los
mechanisms of
procedimientos
the
especiales
Council
que a
and
veces se
special
pueden activar de
procedures,
manera
which can
simultánea, porque
sometimes
los procedimientos
run at the same
especiales no
time.
van a
Sometimes
determinar, no
special
van a analizar
procedures
un
will not
caso y
determine
publicar
or
una
will not
decisión
analyze a
pública,
case or
sino
publish
que
or
lo que
make
harán
public
son
make a public
cartas
decision,
confidenciales al
but they
Estado,
will send
comunicaciones, etcétera,
confidential
pero pueden
letters
ser
or
complementarias
communications to the
y no
state,
tienen los
but
mismos
they
requisitos,
can
no
be
se requiere agotar
complementary.
los
They don't
recursos
have the same
internos,
requirements. So
etcétera, no se
in
requiere consentimiento de las
domestic
víctimas, entonces
resources do
son
not have to be
mecanismos
used
más
before.
expeditivos, más
So
ágiles,
they are more expedite,
pero
more
aquí nos
agile
situamos en
mechanisms.
los órganos de
But
tratado en el
here
terreno
today we will talk
cuasi-judicial,
about
lo que sería
treaty
más
bodies,
parecido
and that's
a una
more
corte internacional.
similar to
Sí,
how an international court
siguiente
would operate.
diapositiva.
So a lot more structured
Tenemos,
and
como
formal.
ustedes saben, hay 9
As you know,
tratados
there are
principales de
9
derechos
main
humanos en el marco
human rights
de la ONU,
treaties
algunos
in the UN
transversales
framework.
como el
Some of
Pacto
them
Internacional de
are
Derechos
more
Civiles y Pacto
cross-cutting,
de Derechos
like the
Económicos, Sociales y Culturales, y otros
Economic,
específicos
Social,
sobre
and Civil
algunas áreas
Rights
temáticas
Treaty and some
o
other specific
para proteger
thematic
algunos
areas,
grupos
or some that were
de
created to
víctimas.
protect specific
Los
groups of
mecanismos
victims.
de
But
quejas individuales están reconocidos a
individual
veces en
complaints
un protocolo
mechanisms are
facultativo a estos
sometimes
pactos,
included
como es el
in
caso del
an
protocolo
optional
facultativo al Pacto
protocol,
de
such
Derechos
as the
Civiles y Políticos
Protocol
o al
for
de
Civil
Derechos
and
Económicos,
Political
Sociales y
Rights, or
Culturales, o
Economic,
al de la
Social, and
CEDAW,
Cultural
o
Rights,
al
or
de
the
la
CEDAW,
CRC, que son la Convención de Derechos
or
del Niño, o
CRC
a la Convención
for
de Derechos de
children's
Personas con
rights,
Discapacidad,
or
u
for
otras
people with
veces en una
disabilities,
provisión,
and at other
en un
times
artículo específico
in
de
a
los
provision
tratados,
or a
como es el
specific
caso de la
article
Convención
of the
contra la
treaty,
Tortura.
as is the case of the
En
Convention
todo caso,
Against Torture.
los estados tienen que
In any
voluntariamente
case,
reconocer
states
la
must
competencia de
voluntarily
los comités para recibir
recognize
quejas
the
individuales. Es el
authority, the
primer requisito.
jurisdiction of the
Entonces hay que
bodies.
ver qué
That is the
tratados
first requirements.
un
So
estado en
the
cuestión
first step to
ha
analyze
reconocido,
is
por ejemplo, qué
which
protocolos
treaties have been
facultativos ha
signed and which
ratificado o qué
protocols have been
declaraciones ha hecho
ratified by
bajo el
a
artículo
state, what
correspondiente del
declarations have
tratado.
been made
Eso es
under
lo primero
certain
que
articles of
tenemos
the
que ver.
treaty. So that's the first
Siguiente
step to
tratado.
determine.
Entonces les decía, actualmente hay
As I
8
said,
comités
today
que pueden
there are
recibir quejas
8
individuales.
committees that
El
can receive
noveno es el
individual
Comité
claims. The
sobre los
ninth, which
Derechos de los
is the
Trabajadores
Committee on
Migrantes y sus Familias, todavía no ha
migrant
recibido el
workers' rights and
suficiente
their
número de
families,
ratificaciones
still
para
does
poder
not
entrar en
have
vigor. Sin
enough
embargo,
states
los
ratify
comités
it for it to
reciben
come into
muchísimas
effect,
quejas
but committees do
relacionadas con el tema de
receive
la
very
migración. De
many
hecho,
complaints
el mayor
related to
número de
migration.
quejas
In fact,
recibidas
the
por
highest
los
number of
comités
claims
de Naciones
received
Unidas
by
están
UN
relacionadas
committees
con
are
el tema de la
related
migración. Es el
to
primer tema
migration. That is
por el que
the
recibimos
number one
quejas individuales,
thematic
y
area
eso es
for
porque
which we
algunos
receive
tratados,
individual
como la
complaints.
Convención
And that's
contra la
because some
Tortura o
treaties,
la
such as the
Convención
Convention Against
contra las
Torture or
Desapariciones
the
Forzadas,
Convention
tienen
Against
una
Forced
prohibición específica que
Disappearances, have
prohíbe
a
el
specific
retorno hacia
provision
un país donde
to
habría un riesgo de
forbid
tortura, por ejemplo, o un
refoulement
riesgo
or
de desaparición
deportation to a
forzada,
country where there is
pero
a risk
otros
of
tratados
torture or forced
han sido
disappearance.
interpretados
And there are
como que
other
incluían
treaties that
también esa
have been
prohibición de
interpreted to
non-retorno o non-refoulement, como
include
es en
also
el
that
caso del
prohibition
Pacto Internacional de
of
Derechos Civiles,
non-refoulement, such as the
el artículo
Civil
7, la
and
prevención de
Political Rights
tortura
Treaty, and
o
Article
tratos crueles
7.
sin humanos o
There's
degradantes, o el
it's
artículo
about
6,
torture
prohibición
prevention,
del
or
derecho a la
Article
vida, se
6
han
on
interpretado que
uh,
también incluían
the
ese
right
aspecto
to
de
life. So
previsión
that
de
also
retorno, o
includes that
también la
principle of
CEDAW o
non-refoulement.
el Comité de Derechos de
CEDAW,
Personas con
or the
Discapacidad o
Committee
el
for the
Comité de
Rights of
Derechos
People
del
with
Niño,
Disabilities,
ha
the
recibido
Committee on
un número
Children's Rights,
importante de
they have all
casos
received,
relacionados
in fact,
con
they receive a
retorno
growing
de
number of
personas
cases related to
migrantes
this
o de
principle of
demandantes de
non-refoulement,
asilo o de
about
refugiados
asylum
hacia
seekers,
otros
refugees, or
países.
migrants who
Siguiente diapositiva,
want
por
to be
favor.
deported to their countries of origin. Next slide,
Si
please.
miramos más ampliamente
If we
qué
look
tipo de
more
casos hemos
broadly
recibido
at the type of
relacionados
cases that have been
con el
submitted
tema de la migración,
related to
el número más
migration,
importante tiene que ver
the
con
highest number of
non-refoulement o
cases refer to
casos de
non-refoulement,
retorno hacia país de origen o hacia un tercer
forced
país,
return
ya
to either their
sea
country of origin or
el
a
retorno
third
clásico con un
country,
riesgo
whether it's
de
classic
daño irreparable
deportation with a
o
risk of
retornos
irreparable
bajo
damage, or
las
refoulement
regulaciones de Dublín
in under the so-called Dublin returns, or in cases where there would be a lack of access to medical treatment that would be essential for victims, or with a risk of female genital mutilation or other similar practices. We have also received cases of pushbacks or deportations in the border, cases of migrant detention, specifically of migrant children and migrant families, also cases related to children, in particular cases of age determination, unaccompanied minors who did not have legal documents, or they did have documents and they were not considered valid, refugee status determination, lack of guarantee or lack of representation in cases, and the lack of procedural guarantees during asylum processes, for instance, lack of consideration of the higher interest of the child, or simply ignoring their voices, all of which should be specific, which are rights gathered under the Convention for the Protection of Children's Rights. We also have received cases of family reunification, and one in the Human Rights Committee had to do with rescue at sea. To highlight some positive developments, and perhaps we can reflect why the committees receive so many cases related to migration. First, despite the fact that it's an almost judicial system, and there's a whole discussion as to whether the decisions should be binding or not, we do see that there's a high level of compliance with views and interim measures, especially everything related to some of the more recent committees. For instance, the Committee on Children's Rights, there's a 90% compliance, and also a high level of compliance with interim measures or protection measures, especially in cases of returns. That's essential because it demands an immediate response to suspend refoulement or returns of individuals. So, of course, the impact in those cases is immediate. And when countries do respect what we have seen, that countries have mostly respected those measures and views. Something else that's positive is that in many of these cases, decisions have led to reopening the proceedings. So it's not only that returns have been prevented, but asylum processes have been reopened, reconsidered, and sometimes that has led to granting of asylum. To tell you more about the process, it's not quite a cycle because it's not the periodic revision of states, but it all starts with a complaint that is submitted. Then I will explain how those complaints may be submitted, but once they are submitted and before they are registered, we call it registration, and that's the moment when the complaint receives a number. So the petition section reviews them, and when they assign a number to them, that means that it is sent to the state for observation. And once the case is procedurally ready, then it would lead to a committee's decision. Once it is registered, that's the moment when it is considered that interim measures should be taken, or protection measures. They are referred to with both names in the treaties, to prevent an irreparable damage to the victim while the committee decides, because these cases may be reviewed for several years. So that is determined at the moment of registration. Then it is communicated to the state, and the complainant will also get a response. So that's the next stage of communication between the parties. Then there is a closed hearing, a private session. Most of the times this happens in writing. It doesn't usually happen that there are public hearings. It has happened in three cases: in the Human Rights Committee, the Committee Against Torture, and the Committee on Children's Rights. The most recent case was one on climate change. And soon, the Committee on Forced Disappearance will also have a public hearing for a case of forced disappearance. But four cases really show you that it truly is an exception in the case of individual complaints submitted to treaty bodies. So after the examination, the decision is made public, and if a violation is determined, there are means for redress, and the final step is follow-up or enforcement of the decision. So the state is asked for information on the measures that will be taken to guarantee compliance with the decision. The state is usually granted 6 months to guarantee compliance, and afterwards, complainants can also submit their responses. In some cases, there have been third parties who have also intervened, and those interventions are becoming more frequent, in fact, not only during the process, but in the follow-up phase. This slide outlines with a bit more detail the procedure that I've just explained, simply to clarify that upon registration, contrary to what happens in the inter-American system, what happens is that admissibility and the merits of the case are considered jointly. Exceptionally, the committee might present observations on admissibility. In that case, we call it a split request. That is, when we separate admissibility versus merits. In the rules of procedure, there's still a possibility for the state to ask for that split request, but that possibility has been suspended because of lack of resources in our section, and therefore a split used to take two further steps. And for all of these reasons, the possibility has been suspended. However, the committee may still decide upon registration to make this split, to separate admissibility versus merits. More practical information on how to submit a complaint. Currently, in the last year, we have a website, a portal that you can access online to directly submit your petitions or complaints. It guides petitioners and complainants step by step on how to submit their petitions. There are pop-ups with information about whether they are sending a complaint to a committee where perhaps the state in question has not really ratified the protocol in question, then that information is sent. And that also helps to expedite the process for us. It's a first filter. But since there are still some technical issues with the portal, if there are any technical issues, it is also possible to print the Word form, which can be found here if you click on the link on this slide, and send via email to the email you also see on screen, ohchr/petitions@un.org. This email is still in use, and in fact, most complaints that we receive on this email. So right now we're working on these two different portals. Perhaps in the future, it will all be concentrated on the portal. Regarding languages, complaints may be submitted in English, French, Spanish, or Russian. If there are appendixes in other languages, they should be translated into one of these four languages. We are currently in the process of adding Arabic as fifth working language for the committee. And another important information is that if you request interim measures, then that request must be sent 3 working days prior to the event. So, for instance, if we are talking about a deportation case, if there is a date when the refoulement will be enforced, then that must be sent with the request for interim measures at least 3 working days prior to this date so that our section can process it, so that the committees in different time zones can make a decision and the state can react.
Por favor. Otro detalle también a
Another
resaltar es la
important
diferencia con el
aspect
sistema
to
interamericano es que
highlight,
las
a
medidas
difference
cautelares
with
no se
the
pueden presentar
inter-American
de
system, is
manera
that
autónoma,
interim
sino que
measures
tienen que
cannot
ir
be
siempre
presented
asociadas a una
separately. They
queja
must
individual.
always be associated to one of the individual
Entonces,
complaints submitted.
¿qué criterios tiene que cumplirse o condiciones
What
tiene que
are the
cumplir una queja
admissibility
para que pueda ser
requirements that a
examinada
complaint
por un
must be
comité?
met in order
Estos son
to be
condiciones de
examined
admisibilidad,
by
pero ya al estado del
committee? So these are
registro se
admissibility
ve que se
criteria,
mira que se cumplan con los requisitos
but at the
básicos.
very
Por ejemplo,
beginning,
en primer lugar,
criteria
que
must be met
estemos,
by filling the form.
que
So first of all,
el Estado contra el que presentan
the
la queja
state
haya
against
reconocido
which
la
the
competencia
complaint
del
is being
comité
submitted
para
must have
recibir
recognized the
quejas individuales.
jurisdiction
Y
of the
eso lo pueden
committee
ver a
in order
través
to
de
receive
este
that
vínculo.
individual
Luego podemos
complaint. And you
compartir
can
esta
find this
presentación para
on
que tengan
this
la
link.
información a
We will
mano.
be sharing the presentation
Pueden ver
afterwards so that you
si
can
el
access
Estado
all
ha
of these links. And there
ratificado
you can see
el
if the
instrumento
state
de que se
has
trata.
ratified the
Hay
instrument
algunos
in
comités en
question.
particular
There
que
are
tienen
some
además
specific
unos,
committees that also
unos
have
plazos específicos para poder
more specific
recibir
deadlines
quejas individuales.
to receive
Es el caso
complaints,
de el SESC, el
such as
Comité
the
de
case
Derechos
of
Económicos, Sociales y Culturales y el
the
Comité de
Economic,
Derechos del
Social, and
Niño,
Cultural Rights
establecen un
Committee
plazo
and the
de un
Children's
año
Rights
desde el
Committee.
agotamiento de
They
recursos internos.
have a
En el
deadline of
caso
one
del Comité de
year
Derecho
after
para la Eliminación de la Discriminación Racial es de 6 meses. Y
resources have been
el
used up,
Comité de Derechos
and
Humanos
the
ha
Committee
establecido en su
Against
reglamento
Racism,
un
six
plazo de
months, and for
5 años
human
desde el
rights, there
agotamiento
is
de
a deadline
recursos
of
humanos
five
o
years
2 años desde haber agotado el
after
sistema
all
regional,
national resources have
desde
been
haberse
used, or
dictado
2 years
la
since
decisión a nivel
after
internacional o
regional
regional.
mechanisms have been
Los
used up.
demás comités, como el de
The
la
rest
CEDAW,
of the
por ejemplo, no
committees,
establecen
as is the
plazos
case of SEDAW, for
específicos para
instance, don't
presentar
have specific
comunicaciones.
deadlines
Sin
to
embargo,
submit
un plazo muy
complaints.
amplio, como por
However,
ejemplo 10 años desde el
if
agotamiento,
you
podría
consider a
considerarse
very
un
long
abuso del
period, like
derecho a
10
presentar
years
comunicaciones y
after
considerárselo
a
excesivo.
situation happened, is generally
Entonces,
considered too
reconocimiento de la
long a
competencia
period and is
mediante la
usually
ratificación
dismissed.
o mejor
So,
mediante la
first,
declaración del instrumento
recognizing that
del tratado
the
correspondiente,
committee has
plazos a
jurisdiction
algunos
because the
comités
committee was
y el
ratified,
tercer
some
requisito es
deadlines,
que
and the third requirement to
cuenten
be
con
met
con la
is
autorización de la víctima. Si son
that
representantes, las quejas
victim
las tiene que
status is
presentar la propia
determined. So
víctima. Si
complaints
son
must be
comunicaciones
submitted by the
individuales, por
victim
tanto,
themselves.
tienen que
They are
ser
considered
de los
individual
individuos, no se aceptan
communications,
las
so they must be
comunicaciones
submitted by
anónimas.
them.
Sin
They
embargo,
cannot be
algunos tratados
submitted
también aceptan
anonymously. However,
quejas
some
presentadas
treaties
a nombre de un
do
grupo de individuos.
accept
Y, por
uh,
ejemplo, el Comité de Derechos del Niño ha
complaints
aceptado
presented by
quejas
groups. For
presentadas
instance, in the
a nombre
children's
de
rights
un
committees,
grupo delimitado de personas,
cases or
también el
complaints have
SESC,
been submitted for a limited
sin que
number of
constaran los
people.
nombres.
The same thing goes for
Entonces
the
tienen que tener representación
economic, social, and
explícita con la
cultural
firma
rights
de las
committees.
víctimas
So the victim
y
must have
tienen que ser
authorized the
víctimas
submission of the
actuales o
complaint.
potenciales de
Victims must
violaciones de derechos
be,
humanos.
well, either victims or
El
potential
comité
victims
tiene
of
que
human
tener
rights
competencia y
violations.
tiene que tener
The
jurisdicción,
committee
por
must have
supuesto, es
jurisdiction
decir, la persona que tiene que
and
encontrarse
competence. That
bajo
means
en el territorio o bajo el control
that
efectivo
the individual
del
must
Estado
be under
de
the
que se
effective
trate.
control of the state
Por
or
ejemplo, si
within
se
the
trata de
territory of that
personas
state. For
migrantes que
instance,
están
if we are
sujetas a una
referring to a
orden de
case of
retorno, por
migrants
supuesto, y que se
that
encuentran
are to be
bajo el
returned,
control y en el
then
territorio del
they
Estado
are
que va a expulsarles,
in the
hay
territory where
jurisdicción.
they will be returned,
La
of course.
competencia
If that
tiene
is
que
the
ser
case, then there is
también
jurisdiction.
temporal, es
Then
decir, hay que
competence
mirar
must
en qué
also be
momento el
considered
Estado
in
hizo
terms
esta
of
declaración de competencia o
time. We must
ratificación,
see
porque es a
when the
partir de ese
state
momento
ratified
que se
the
vincula
committee,
con el
because it is
procedimiento de
after
quejas
it is
individuales,
ratified
es lo que se
that
llama la
we
competencia
have
temporal o
jurisdiction.
competencia
So
ratio
that's
temporis. Sin
temporary
embargo, puede tratarse de
competence.
violaciones que hubieran empezado
But there may
antes
also be cases of violations that
de
began
ese
before
reconocimiento, pero
that
que continúen
ratification,
después de
but
esta
that
ratificación o
continue
reconocimiento,
after the ratification.
o por ejemplo, que haya
Or
procedimientos en
perhaps
curso
if
después de
there
esa
are
entrada en vigor
processes ongoing
del tratado.
after the treaty has come into
Luego podemos
effect.
entrar en más detalle si
I
hay
can go
preguntas
into
sobre
more
cada uno de
details
estos
if there
motivos,
are
porque es
questions about
bastante
any of these
importante
specific
discutirlos con
requirements,
detalle.
because I think it is
El
important for you
agotamiento
to
de
have a
recursos
clear understanding of
es
them.
una
The
condición muy
exhaustion of domestic
importante,
remedies is a very important
por los principios de
condition or a very
subsidiariedad.
important criterion to be
Las
met.
víctimas no pueden acudir
Victims
directamente a la vía
cannot
internacional,
go
tienen que
directly
primero
to
intentar agotar
international
los recursos
mechanisms. They first
administrativos
must
y
go
o
through all
judiciales que
domestic
estén
remedies,
disponibles
including
y que sean
administrative or
eficaces
legal
a nivel
remedies
nacional, que
that
estén
are effective
disponibles a las víctimas
within
y que
the
sean
country,
eficaces,
anything that is
incluido
available
que no
for the
haya
victims, and
dilaciones
that they
indebidas
are
y que
effective,
sean
meaning
recursos que
that
puedan
they are
otorgar
not slowed
reparación a
down
las
for reasons
víctimas
that
por
are
las
considered
violaciones que están
unreasonable,
invocando.
and that they can offer
Tienen
redress
que
to
haber
victims.
invocado lo que invocan ante los comités, cada uno de los
Something else
reclamos ante los comités lo
that
tienen que
each
haber
of the claims
invocado a nivel
submitted
nacional, al menos en sustancia, es decir,
must
no
be
necesariamente
issues
invocando
that
el
have
artículo del
already
tratado
been
correspondiente,
presented as
sino
complaints
al menos
in
el equivalente
domestic
a nivel
remedies.
nacional
So
o en
if it
sustancia
is not
la
exactly the
queja
same, at
correspondiente.
least in terms of the merits or the substance of
Después,
the
el mismo
case,
caso
they
no
must
puede
have
estar
been already
pendiente al
treated
mismo
through
tiempo ante
domestic
otro
remedies.
sistema, como puede
Then
ser la Comisión
litis
Interamericana.
pendens,
No
meaning
pueden,
that a
a no
case
ser que sean
cannot
medidas
be already
cautelares
open
solamente.
in
En
the
ese caso sí se
Inter-American Court
podría
unless
presentar
we're
al mismo
talking
tiempo
about
la
interim
comunicación
measures
ante
or
un
precautionary
comité u
measures.
órgano
If
del
that is
tratado.
the case,
Pero
then
si está
you may
pendiente, es el
use
mismo
both
caso, las mismas
resources at the
partes,
same time.
las
But if it
mismas
is the same
alegaciones, los
case,
mismos
same
hechos,
party, same
entonces no puede
allegations,
estar
same
al mismo tiempo ante
facts,
ambos
then
sistemas.
the case cannot
Tampoco
be
si ya se
open
ha
at the same
pronunciado
time in two
la
separate
Comisión o
systems.
la Corte
If the
Interamericana
Commission or the
o la Corte
Inter-American
Europea
Court
o el
or
Tribunal
the
Europeo en
European
Estrasburgo.
Court, the
Creo que
Strasbourg
estamos
Court
en la
has
región
already
europea y americana, por tanto no me refiero a
made
otras,
a
y
decision. That's why
la Comisión
I'm more
Africana
familiar with
o la
Europe
Corte
and the
Africana.
and Latin America, which
Entonces,
is
en
why
ese
I
caso,
mentioned these two mechanisms,
también
but
tampoco se
also the
podrían
same thing
pronunciar
applies for
los
Africa.
comités, a
If
excepción
if that
del
is the
Comité de
case,
Derechos
then the
Humanos,
committee
que
will
sí
not be
permite
able to
que
present a
ya
decision, except the
cuando
Committee
ya
on
han
Human
acudido
Rights.
a otro sistema,
That is the only
todavía
one
puedan
that
acudir
even
con el mismo
after
caso ante el
a
Comité
case
de
has
Derechos
already
Humanos.
been
Es
submitted
la excepción,
within
otros
another
comités no
system, it can
permiten
still
una
come
vez ya se ha
to
pronunciado.
this committee.
Otros
The other
sistemas no
committees may
permiten
not.
poder
If
recibir ni
another
examinar el mismo
system has
caso.
already
Y
analyzed
también
this case and
se
come to a
requiere que haya
decision, then
suficiente
they cannot be
sustanciación de
reviewed by
las
the
quejas,
committee. And of course,
suficiente
there must be
información y
sufficient
fundamentación de cada
substantiation
uno de
of
los
claims.
reclamos.
So the merits
Hay que
to each
decir
of the
que
complaints must
cada
be
uno
sufficient, must be
de las
clear.
quejas
For each of the
hay
complaints,
hay que invocar específicamente cada una de las quejas, idealmente
there
también
must be
refiriéndose a los
specific details
artículos
for
del
each of the
tratado
claims,
correspondiente,
and
porque los
ideally
comités no
with a direct
suelen
reference to the
pronunciarse
articles of the
sobre una
treaties,
queja,
because the
no suelen
committee will
actuar
not make a
ex officio y
decision
pronunciarse
on
sobre
a
una queja si
complaint
no lo han
overall. They
invocado
never act ex
los
officio
peticionarios.
unless
Entonces es
the claim
importante
has been
invocar cada una
directly stated.
de las
So
quejas que quieran
articles
encontrar
and
reflejadas.
complaints must
Es
be
importante
very
también
specific, very
pedir cuáles serían
detailed,
las medidas de
and it's
reparación
important
que
also
consideran
to
que
know,
serían satisfactorias
or the
para el
claim
caso.
must also
No
include
significa que el comité las vaya a
what
retomar, pero
redress is
es un
expected. This
indicador
doesn't mean that
importante
that
para
is
el
what the
comité.
committee will
En
decide,
particular,
but
medidas
it's
como
important for the committee to
pedidos de
know,
perdón
especially,
público,
I don't know,
etcétera, que
if
puedan
it's
ser
a
más
public
afines
apology that is
o más
expected, or
culturales,
anything else that might have a
o regionales.
cultural or
Es
regional
importante, o si
significance,
necesitan, por
it would be
ejemplo,
very important for the committee
atención
to be
médica,
aware.
atención
Or if
psicológica, más allá de las medidas físicas que
either
pueda ser la
healthcare, medical care,
compensación, es
psychological
importante
care is
incluirlas también
necessary beyond any
en la
other forms of
comunicación.
compensation. All of that must
Siguiente,
be outlined
algunos
in the
detalles
complaint as
de
well.
procedimiento.
Some additional
En
details related
particular,
to
hay algunos
procedure.
comités que han desarrollado
There are
guías
some
interpretativas de
committees
lo que
that
consideran
have
los criterios
presented or
para
created
dictar medidas
guidelines with
cautelares.
the
Son muy importantes
criteria on
referirse
interim
a ellos,
measures.
como es
It
el
would
Comité
be
de Derecho
important
Sucedido
to
y el
refer to them,
Comité
such as the Committee on the
DES.
Rights of Children or
También
DES.
varios comités, ahora
There
ya son
are
5, los
several
que han
committees as well. Well,
adoptado
in fact, five
directrices sobre
specifically have
intervención
adopted
de terceras
guidelines on
partes. No
third-party
hemos hablado mucho de ello,
interventions.
pero
I
los
haven't given
comités
you a lot
publican
of
una lista de
information
casos
about this,
pendentes
but
y para ello hay
committees
que estar
publish a
mirando,
list
no
of
estar la
pending
información
cases.
consolidada,
and the information is not consolidated in one place, so you have to go through the website of each of the committees in order to have the information. You will also find open cases or a list with open cases if you're interested. Usually researchers, NGOs working in this area are interested, especially in submitting an amicus brief, so a third-party intervention. That is possible, and the guidelines explain how to do so. Some committees have also created guidelines for oral hearings.
Diapositiva, por favor. Voy a terminar refiriéndome a alguna
I will
información estadística para
finish my
dejar un tiempo
presentation with some
para que los
statistics so that we
participantes
can
los
leave a
vean.
little bit of time for Q&A at the end.
Entre el año pasado y
So
2024,
between last year and
para
2024,
darles una idea de cuántas decisiones se
just to
adoptan,
give
tenemos
you an
cerca
idea of how
de
many decisions are
400
adopted, we see around 400 cases every year,
casos anuales. Esos son
400
los que
new
se
cases
registran,
every year.
los que ya se
These
han
are the ones
registrado.
that are
Y se
registered,
adoptan el
recorded.
2023
And in 2023, we adopted
casos, siempre se van recortando fragmentos.
282. We always
Este
have
año
around
hemos
300.
adoptado
In
mucho
2024,
más
we
por dos
have
motivos. Uno es
adopted
que
many more
tuvimos un
for
caso
many
que incluía
reasons.
250 comunicaciones,
On the one
lo
case,
cual
because there
se
was one
anularon,
case that had
entonces
250
esto hace
communications,
ir mucho a las
so
cifras,
this
pero
makes the
también
numbers go
porque
up
a pesar de que
significantly.
hemos tenido problemas de
But also,
financiamiento en Estados
despite
Unidos y
the
la
funding
burocracia
problems that we've had
regular y
in the United
facilitadora,
Nations under the
especialmente
High
incluyendo la
Commissioner,
nuestra, entonces hemos
including
tenido menos
our
capacidad de
section, we've
realizar
had
casos,
a lower
pero sin
capacity of
embargo
working on
los
cases.
comités han adoptado
However,
varias medidas
committees
para
have adopted
hacer frente al
various
retraso en la
measures
consideración de
to
casos.
face the
Una de ellas ha
backlog.
sido juntar quejas
And
o
one of
agrupar
those
varias
measures
quejas
has been to
cuando son
put
similares.
various claims
Otro ha
together
sido el caso piloto.
when they're similars.
En el comité DESC
The
adoptamos
other
un
one
caso piloto
has
porque
been
tenemos
a
muchos
pilot
casos
case that we have adopted
de
because
desalojos
there
forzosos
are many cases of forced
el Comité
relocations,
de Derechos Humanos ha
and
adoptado
the Human Rights Committee
un
has
procedimiento simplificado para
adapted
casos
a
repetitivos. Entonces, esas
modified
medidas han permitido
procedure for
la
repetitive
adopción de
cases.
mayor
So
número
that is why we see a greater
casos.
number this year of
Siguiente
decisions
diapositiva,
adopted.
por favor.
Next slide.
Pueden ver un poco la proporción.
In this graph, we can see a bit of the breakdown. Most of the cases have been directed to the Human Rights Commission
También por el número de ratificaciones
due to the number of ratifications that it has had. It has 116 states that have acknowledged their competency of receiving individual cases, while the others are much recent cases, with the exception of CERT. Most of them are recent cases. For example, the facultative case of DESC, they have only 30 ratifications. That is why we see a difference here. And also the CRC started working and it's been in operation for the last 10 years only. So the pending cases that we have are around 2,000. Next slide. And a very important information, how long it takes to decide, right? It averages between 2 and 4 years to decide from the moment it is recorded. We need to understand that there can be a 1-year delay for every case now, unless there are other conditions that make their reception immediate. But otherwise, it can take several months to be recorded. There are some committees that have very little delay, as is, for example, the forced disappearance cases, and on the other side, we see the Human Rights Commission that has the most number of pending cases that it takes around 2 to 4 years to be resolved.
Me quería referir a
Next
algunos
slide.
links que pueden ser de utilidad.
And I
El
just wanted to
primer
show
link
as
es
well a
la
few links that
página
could be
de la
useful.
sección de
The
peticiones,
first
donde
one
tiene
is
la
the
información
petitions
general.
webpage,
Sin
which
embargo,
has
es
general
importante también
information.
visitar bajo la página de cada
However,
comité
it is
la
important to
parte de
also go
formulaciones
to
individuales,
each
donde
of
tiene
the individual
inventario de estatus
commission's websites
pendientes,
because it has
directrices
details around pending
sobre
cases,
medidas cautelares,
guidelines
etcétera,
around
información de seguimiento,
cautionary measures,
informes de
also
seguimiento, bueno, toda la
follow-up
información
guidelines
detallada bajo la página de cada comité.
and
Y
instructions.
después la información
And
sobre
then we
dónde
also see
acceder al
information
formulario y
on
a la
where to
nota
have
del
access
día
to
para
forms,
presentar casos
to the
individuales
guidelines,
y
so that you
también
can
cómo acceder
present
a la jurisprudencia.
individual cases and how
Nuevamente
to
hay
have
dos
access to jurisprudence as well. There are
bases de datos
two
fundamentales para
databases
acceder
that
a
are
la jurisprudencia. Una
fundamental to have
es
access to jurisprudence. The first one
la Juris
is
Database, que es este link
the
en la
juris
pantalla,
database that we see here, which is
database que permite la base de
juris.ohchr.org.
datos que
This is the
permite la
database
búsqueda
that allows
temática por
for
estado, por
a
comité,
search
por tipo
per theme, per
de
committee,
decisión,
per
etcétera, por
state,
palabra
per
clave.
type
Entonces la
of
la
decision,
base de
even
datos más
keywords.
útil para la búsqueda de
This
jurisprudencia.
is the
Sin
most
embargo,
useful database,
no está totalmente completa, siempre
jurisprudence
hay un desfase hasta
for
que las decisiones no
search.
están
However,
editadas
there
y
is
traducidas.
always a little bit
Entonces,
of
para
delay
tener
to show the
acceso
most
a
recent
todas las
ones
decisiones de
because they need to
manera
be edited and
integral,
translated.
pueden
So to
usar
have access to a
otra base de
comprehensive
datos que es la de
record,
los órganos
you can
del
have access
tratado,
to
que me doy
the
cuenta que no está
treaty
incluida aquí, pero se la pongo
databases,
en el chat.
which I realize is
Y
not included
finalmente
here, but I
referirme
will
a
add it in the chat just
lo que
now.
llaman jurisprudence highlights,
And
como
then what is called jurisprudence
las
highlights.
decisiones más importantes de
These are
jurisprudencia
the
se
most
publican
important
de manera
jurisprudence
regular,
decisions that
cada 4
are
meses
published
o
every
actualmente
4
tenemos más
months.
retraso, pero vamos a sacar
We
ahora las
have
últimas
a
decisiones
little
de
bit of a
junio,
delay this year,
donde es
but
una
they are going
compilación
to
de
be
las decisiones
published
más
soon.
importantes con un
This is a
resumen y
compilation of the highlights of
con un link
jurisprudence
a las
cases
decisiones.
with a link to the corresponding
Con
case
esto
as
voy
well.
a terminar mi presentación aquí
Okay,
para
this is
dar
the end of my
más tiempo para
presentation.
preguntas
Thank you very much for
y
your time.
respuestas.
I'll leave some
Muchísimas
time
gracias
for
por
Q&A.
su atención.
Thank you for your time again, once again.
Muchas gracias a ti, Ana. Y
Thank you very
pasando
much,
en
Anna.
atención al espacio de preguntas y
And
respuestas,
yeah,
le
of
cedo
course,
de inmediato la palabra a
I will
Rafael.
now pass the floor to Rafael
Muchas
to
gracias,
guide the
Rafael.
Q&A. Thank you so much, Rafael.
Gracias, Silvia.
Bienvenido.
Thank you, Sylvia.
Gracias, Isabela, Paula.
Thank you, Isabella, Paula. Thank you to the whole organizing team for the invitation. It is always great to see and to hear Ana Batalla. It is amazing to hear updates on all of these cases.
No gaste más de 10 minutos en explicar un caso.
And
Creo que dejaré seguro muchos detalles para
I
las
am
preguntas y
sure
respuestas.
there will be a lot
Voy a
of
compartir
time for
una
Q&A because I'm
pequeña
going to take
presentación.
just about 10 minutes to
¿Vale?
explain one of the cases.
Simplemente
And
para guiarnos
I'll
un
share my
poco
screen now, if that's
el
okay,
contenido de la presentación.
just to go a little bit deeper on the presentation.
Vale, entiendo que se ve la presentación. Sí,
Okay, can you see my presentation?
Vale,
Yes, thank you.
vamos a
Perfect.
comentar un
Okay,
caso cuando nos
so let's talk
propusieron
about
participar, teníamos dudas,
one case study.
¿no? Datos
When I was invited to
sintéticos, hipotéticos
participate,
siempre, ¿no?
I was a little bit in doubt
Con la
around
intención también de ir un poquito más
which
allá
case
del
to
resultado
present
final, de la
and
implantación jurídica de una decisión,
thinking
cuál va a
about
ser el
the
valor que esta decisión ha
legal
tenido para cambiar
basis for
las
this
perspectivas de futuro, lo que comentaba Ana, igual como primera
of what is a
perspectiva más
case that could
estructural al final de
change
una
the
decisión,
perspectives for the future, some
incluso
structural decision
alternativa o incluso que no haya
for the
terminado
future.
precisamente como queríamos y que haya servido para
This could be a case
cambiar
that perhaps
estructuralmente
didn't
alguna
end
previsión negativa
as
o en este
hoped,
caso en este acuerdo,
but
¿no?
that it was perhaps
Dentro
useful
de
to
esta
change
búsqueda
administrative
de
cases.
este
So,
proceso
as
de
part of
buscar
this
resolución de
search
perspectivas
or
estratégicas, alguna de
this
las decisiones
process
entendíamos
of
que pudiera ser
strategic
de interés para la
cases
audiencia
that could be
y
interesting
decidimos
for this
finalmente
audience, I
hablar
decided
sobre la
finally
decisión de medidas
to
cautelares,
talk
que
about
comentaba
a
Ana, que es uno
cautionary
de los
measure
ámbitos en los
case,
que
which is
además los
one of the
estados
areas in
más,
which states
por lo menos, presentan menos
at
objeciones a la
least
ejecución en
have the
determinados
least
aspectos y
objections
para también
in
plantear
certain
la utilidad
aspects, and
frente
also
a
to
un
talk about the
discurso y un
usefulness
debate
around
que existe a día de
specific discourse that we hear now that is centered around the context of the overload of work on the treaties and delays in the decisions, and also the usefulness of this type of cases. And this one was particularly and strategically useful. So this is something that I'd love to share with you. This was a case of a return of minors to Morocco by Spanish authorities as part of the Spanish territory that is located a piece in the Ceuta Autonomous Region in the African continent that has a border with the Moroccan state. And in some cases, it is used as a tool, a diplomatic tool between Morocco and Spain. This was a claim before the Committee for Children's Rights. And we will explain why this was the case, because there were some migrants as well that had a group of children or minors as part of it. So as a context, in May 2021, as part of a diplomatic crisis between Morocco and Spain, Morocco opens its borders, voluntarily opens the border between Morocco and Spain. And in May 2021, it is estimated that, as per public data that's available, around minors, around 1,800 to 2,000 minors crossed the border that you can see here in that photo. Between May and August of 2021, the Spanish government decided to make it clear that those minors would be returned to Morocco. There are some statements by the Spanish authorities that those minors would not be taken as individual cases, that in no case would they be sent to other territories of the Spanish territory in case there was a specific best interest for the minors, which should be part of the state's responsibilities to assume tutorship or care for minors for specific cases. And they were housed in some industrial settings, in some terrible context that governmental authorities and other organizations were working so that those cases would be individualized, so that they could be protected internationally, but also from the perspective of meeting the obligations that have been accepted based on the Declaration of Children's Rights. And this is why we came to that commission, because between 13 and 16 of August 2024, I don't exactly remember which day of the week it was, but it was in the middle of the vacation period. Authorities started at that time to return these minors. They would go with vans from the local police, and with the support of national police officers, they would go to those residential centers where the minors were housed in the mornings. And in groups of 15, as of 13 of August, they started to return these kids from their centers that they were housed to the border in Morocco without any kind of procedure, without letting know the kids or the people that were supporting them that the reason that they were moving these kids is because they were going to be returned to Morocco at that time. This reaches the organizations in the country, and what they did first, the police officers, what they did first is to remove the mobile phones of the minors so that there was no possibility of stopping the returns. The crossing point from there was very close, so they would be returned in a matter of hours. When these cases were known, the modus operandi was not known. It started with one van. We didn't know if the next day would be 5, 15, 30, or whether they were going to continue. So it was very complicated to obtain an effective measure to stop these returns because it wasn't known which kids were going to be returned at the time. That's how we started working with an organization, a grassroots organization that was able to get in touch with residential centers that could get in touch with those kids that were not sent back, and a working group was established to understand what was going to be done. What Ana was explaining, based on the solidarity principle, it became clear that we needed to go to the Committee of Children's Rights. It was something that was to be attempted after the local and domestic measures were already done. So we went to tribunals, and it was only in the case that those measures were denied that we would go to the committee. We didn't know where these measures would go, and it was not an effective remedy between the few hours that the kids were picked up and returned. And in parallel, to try to use the different measures in tribunals, in this case, the tribunals of CETA, whether it was actually feasible to go to the Committee of Children's Rights, even though it might be true that we were not able to stop these measures against the kids. We were trying to help these decisions from the tribunals to stop these cautionary measures for these children, because the capacity that a tribunal from children's rights to determine irreparable damage, for example, in this type of situations, was something that was very important for us to obtain in order to back up what was happening in August. So this is something that we did, and finally, this is a brief explanation of the facts. One of the difficulties that we found at the time was that we needed to justify that there was a big effective risk of potential victims because there was a breach of rights, and that at that time we believed that we had sufficient evidence to show to the committee to take a measure that we understood was complicated, understanding that the procedure was still underway. But in August, we were able to show how this was working. And based on the shifts that the police had, there was no way to identify which kids were going to go first. So the damage we knew was going to happen. So by means of various collaborations with lawyers, we were able to establish a procedure locally and before the committee. We had these three main arguments in order to establish the situation, which is the superior interest of minors and two others. So briefly, I will talk about the strategic value with all of you, that we consider that that were the difficulties, and it was so difficult to establish the predictability of the cases, understanding that there were many risks as well involved. So the first thing is that we needed to have a quick procedure to provide an effective remedy for cautionary measures, so that we can understand what was the justification standard and up to which point would the committee want to establish evidence. And in that case, the decision was quite quick. And important to mention now that it showed a real utility in the legal process that was incorporated as part of the claims, and it was possible to create an interpretation of the damage that was created. The second part was the utility for interpretation for domestic law. Based on this particular case of return, as we have been demonstrated since 2021, and there was a reasonable argument for prospection around the pushbacks on returns, on the treatment of migrants, and the considerations of their individual rights. It is important to start building on this, and therefore the tools of treaties was a very important tool to establish an interpretation or a construal of the law so that we can use them in future cases. In those cases where minors could be involved in order to interpret how they should be used as per the Commission on Children's Rights. And this perspective on children was fundamental as well, so that we could focus the arguments on the character of childhood, so that in this context where the dehumanization of migrant minors is happening, particularly those who have a Maghrebian origin. And it was very important as well to start building a perspective of childhood so that we can bring this case to the Commission of Children's Rights. Lessons and challenges. The effectiveness of the cautionary measures. Someone mentioned here that 90% of the Commission's decisions around children's rights, if I understood correctly, were being fulfilled. This is something that is quite different in other communities, at least here in Spain. And this is a very important piece of information that allows us to be part of the range of options that we usually have around judicial cases in Europe with the European Court of Human Rights, for example. And one of the main problems that is usually brought up, or one of the main debates around what is the correct option here, is through the execution of resolutions that they apply it as per their domestic law. To know that 90% of the decisions of a committee are much more accessible, that is something that we took into consideration, and that was extremely interesting for us in terms of making it easier to establish structural aspects for guaranteeing the rights of minors. The next is a focus on obtaining evidence, particularly important in this context. This is one of the greatest complications in human rights violations, particularly in pushback cases, particularly in return cases. Very, very complicated to obtain documentation coming from victims. One of the greatest challenges. So in that sense, we have seen a very realistic perspective from the committees and an analysis based on the circumstances that we knew that the standard in this case was quite high, but in a contextual case, we were able to get the documentation for 10 people, and then the following, or the rest of the documentation, we weren't able to provide the level of evidence for all the rest. And in a future a discussion with the state around admissibility, that's where we were able to obtain a little bit more evidence so that we can provide the corresponding threshold. One of the main lessons of all of this and keys to success in this case, or keys for this specific case, is that this was not only based on the committee's decisions, but it was also because domestic judges determined that these practices were illegal and there was no legal basis for those actions. So the committee decision definitely helped very much, and it wouldn't have been possible without it. We see this in many cases that we work with. Without the collaboration between legal experts, entities on the ground, lawyers, entities that are in contact with the victims, and the capacity of doing advocacy work, everything that is around this strategic work, without this, we wouldn't have been able to have these cases brought forward. The issue of execution of the resolutions is something that happens everywhere, and this is something that implies as well a responsibility around how to decide and to who to bring these cases to, and how the execution is requested so that the states can execute these decisions and to do it from a point of view from human rights perspective. Thank you very much. I think I kept to my time. Thank you very much, Rafael. Sorry for the interruption. I believe this is great so that we can leave some space for Q&A. And now I can start reading the ones that have already been sent. Those who cannot write it in the Q&A, you can write it in the chat, or you can raise your hands as well. We will be able to turn on your mics. The first one, I didn't see the name, but it says, if the victim has presented cautionary measures or a case into Inter-American Court, can they provide an individual case in the universal system of the United Nations? This is a question for Ana. Thank you very much, Silvia. Yeah, this is a very important question. So if the same claim has been presented to other systems, let's say the Inter-American Court, they cannot present it at the same time to the United Nations committees. However, if the Commission has already sent its resolution, they can also bring it to the Human Rights Commission, because the facultative protocol of Article 5.2a establishes that only if the case is pending, that is when the case can be done, even though in the Spanish version there's a problem actually in that article in terms of translation. But what the Human Rights Committee, they can receive this claim, but not in the Children's Rights Commission. Now, if they have only presented cautionary measures, this does not stop the simultaneous presentation of the claim or subsequent presentation of the case before any of the UN committees. Thank you very much, Ana. Next question. I'm going to read it in English.
Domestic remedies, do you have to exhaust all opportunities to appeal to higher courts?
Sí, hay que agotar hasta la máxima instancia.
That's correct. We need to exhaust all of the instances. It might be up to the Supreme Court of the country in question. Now, several considerations here. If there are several paths, let's say the civil path or the criminal path, you would have to choose one of the paths that could provide remedies. It is not required of the victim to exhaust every possible path in part of jurisdictions, but when they choose one, they need to exhaust all of their options or recourses to appeal or to whatever the case may be. As long as these resources are available and that there are no delays depending on the cases and the complexity of the cases and the information that the state provides on how each of the parties can act. Also, another consideration is whether they are minors. That's an important because the Children's Commission has also made statements that time does not run the same as for children than adults. So in case of a return of minors, it is considered that a year is undue delay in terms of the type of cases and whether if the victim is a minor.
Voy a leer una más y después
Okay, I'm going to read one more question.
Breve,
and then we will do a very brief pause or break to follow the agenda, and then the other questions we can address them as we go. Just to mention as well that the Legal Strategic Council, what we do is also accompany legal cases, and we can help you determine whether this is the right time to bring this before any committee. So if you have a question or a doubt around whether your case can be brought to any of these committees, you can send it via the chat or write directly to me. The last question before the break is the following, and then we can read the next ones. The next question is in English. I'm going to read it in English as well.
For an informative presentation, I have two questions. Regarding domestic remedies, is it required that all effective remedies be exhausted, both judicial and administrative? Creo que ya lo contestaste. It is unduly prolonged delay the only exception. Can anonymity, y la segunda parte de la pregunta dice, can anonymity be provided, requested with regards to the publication of a decision after examination?
Gracias. Sí,
Thank you very much for these questions. Now, in terms of the judicial or administrative paths, so it depends in terms of migration what it is. So the administrative path, of course, it's what has to be taken and it needs to be exhausted, but depending on the case, it could also be a judicial case. Now, in the case of undue prolonged delays, it's not the only exception. There can also be whether there's perspective of success, for example. If I'm going to present a case when the greatest judicial body has already provided a statement around that, I am exempted to present the case because there is no probability of success because the tribunal or the commission has already pronounced itself around that. So there are several cases that could exempt these cases to be presented. I forgot the second question. If you could repeat it, please.
La de los remedios domésticos y la del anonimato. Sí, que sí.
El anonimato. Sí, una pregunta.
Yeah, the anonymity. Okay, yeah, this is an important question. The request on anonymity is that it has to be set the name of the victim to the committee, but the identity of the victim is protected in the public statement. This is something that is done systematically with minors, and also if the victim requests it, it can also be done. Also, in certain cases, actually a very recent case, there was a identity protection with the Commission of Children's Rights, where the name is not provided to even the state for fears of retaliation. We've seen the case of a bombing in a region at the north of Syria where there was a case presented before another state where the name of the victims was not presented, but the operation was known, so the state could respond. There was other cases around sexual abuse in Africa, for example, where the state was requested to respond to to the issue without sharing the name of the victim. So there can be request of anonymity and protection of identity as well. And I know that there is no time to reply to all of the questions, but there was one that I found interesting, which is, what if the states have not ratified the facultative protocol? And this can be presented before other committees, because this is not the only committee that examines or receives this type of issues. The Children's Rights Commission has, for example, received cases around the lack of access to health and education services. So in those cases, they can be presented before other committees as well, whose treaties have this type of faculties or any other discrimination angle to the case. Thank you very much, Anna. Thank you for replying to these questions. We will take a brief break now. You can take a small break. You can stretch, go for a little water break, and we'll be back in 4 minutes.
Muchas gracias. Si pudiéramos ir regresando.
Okay, thank you so much.
Bella, I'll pass the mic to you.
Thank you so much, Sylvia. And I will now quickly, in the interest of time, hand over to my colleagues Paola and Isabella for the second part of the session. We will try to also answer the questions in writing in the chat too, and hopefully we will still have a little bit of time for Q&A at the end of this session as well. Thank you, and over to you, Paola and Isabella, and Sylvia is going to present your slides.
Thank you very much, Bella, and good morning or good afternoon to everyone. It's really a pleasure to be with you, and thanks a lot for your participation and all the interest in this topic. So in the second session, what we are going to do is a presentation of a short selection of promising jurisprudence from the UN Human Rights Treaty bodies, focusing in particular on cases related to the principle of non-refoulement and other human rights that may limit the ability of states to return a person, in particular the right to family and private life and the best interest of the child. And this is not only because a good amount of the jurisprudence of the UN treaty bodies cover these topics, but also because within the migration unit of the Office of the High Commissioner for Human Rights, we have been prioritizing the topic of return. As you can also see from the two documents that we share with you and that my colleagues will very kindly also share now in the chat. So I hope that the selected cases that we will present today can be useful in your strategic litigation, also at the national or regional level, and that somehow can inspire you and your engagement with the individual communication procedures of the UN treaty bodies. I think that these cases can also somehow be useful for advocacy efforts, in particular, for example, to advocate for pathways for regularization and for regular status based on human rights grounds. So I think we can go to the first slide and to the first case. Next, please. Thank you. So the first case is a case of the Committee Against Torture, and it's about the right to rehabilitation of torture survivors. This case is about the removal of an Eritrean asylum seeker from Switzerland to Italy. The asylum seeker is a torture survivor and is claiming that if returned to Italy, basically he will not be able to access the specialized medical and psychiatric treatment for victims of torture that he has been receiving in Switzerland. And this would prevent his full rehabilitation as a victim of torture. Next slide. So what has been the decision of the committee in this case? Yeah, I think if we can move to the next slide, please. So the committee considered that Switzerland, so the returning state, should have undertaken an individualized assessment of the risk of this asylum seeker in case of return, in particular considering his vulnerability as a victim of torture. And in the context of this individualized assessment, the state should have assessed whether rehabilitation services were actually available and accessible for this person upon return, both in the short but also in the long term. And very interesting, the committee concluded that the return to this person to Italy would deprive him of his right to rehabilitation as a victim of torture, and found that the return would breach Article 14 of the Convention Against Torture, which is the article about the right to rehabilitation. Next slide, please. So what we wanted to stress from this case is that basically this case is identifying the right to rehabilitation as a possible avenue to protect survivors of torture from return. And I think it is very interesting because this case is about an asylum seeker, but actually the same reasoning has been applied by the Committee Against Torture, also, for example, in the case of a return of a rejected asylum seeker. And somehow, looking at the right to rehabilitation of torture survivors can expand protection from return. So it could be also an avenue to explore to prevent, for example, the return of irregular migrants who have suffered torture, not necessarily in country of origin, but for example, also in the context of transit or in destination countries, as we know that unfortunately torture is something that is also occurring during migration. Another very interesting point from this case is that the committee is adopting a very comprehensive understanding of the right to rehabilitation. So it's not only looking at the medical services and the medical treatment that the victim of torture will need for rehabilitation, but it's also looking at somehow at the social environment in which rehabilitation would be possible. So, for example, in the case I was presenting, the committee also took into account that the asylum seeker will be also deprived of accommodation if returned to Italy, and also of the emotional support that in Switzerland was provided by family members. And this is also a very interesting point from the case. We can go to the next slide, and to the second case we are going to briefly introduce, which is in this case a decision of the Committee on the Rights of the Child, which is about the lack of medical treatment and the principle of non-refoulement. This case is about a Russian family with 2 children whose asylum request has been rejected. The family was expelled to Russia, and the key issue was that the youngest child is deaf and in need of a cochlear implant. In this case, the committee acknowledged that basically the failure to provide such an implant to the child in a timely manner can cause harm to the child, not only to the child's health, but also to the child development. So in the next slide, we can see the decision of the committee. The CRC held that Switzerland basically failed to establish whether the child will be guaranteed timely access to this cochlear implant, so to the medical care she needs upon return, and also failed to establish whether the child will be guaranteed access to the additional support that will be necessary for her development as a child. So in this case, given that the expulsion already occurred, the CRC requested effective reparation and also request Switzerland to take all necessary measures to prevent similar violations to occur in the future, in particular by ensuring that prior to return, there is a systematic assessment of the availability and accessibility of medical treatment, which is necessary for a child's development. We can go to the next slide. So I wanted to highlight 2 elements from this case. One is the test that the Committee on the Rights of the Child is using for medical cases of migrant children. And it's interesting because the committee is asking states to assess whether medical treatment will be available and accessible upon return. And it's referring to treatment, not only to treatment which is essential for the life of the child, but also referring to treatment which is necessary for the development of the child. So somehow the CRC is looking not only at life-threatening situations, for example, but also at situations where the lack of medical treatment may affect the development of the child. And therefore, the threshold that the CRC is using is somehow lower than, for example, the exceptionality threshold that other human rights bodies, including the Human Rights Committee, are using in medical cases. Next slide, please. Another very interesting point is that in this case, the CRC basically held that the expulsion violates the right to health, so Article 24 of the Convention, read in conjunction with the best interests of the child and also the right to survival and development. So in this case, non-refoulement is applied directly in connection to socioeconomic rights. And this is important because we know that in many non-refoulement cases, the socioeconomic elements are only taken into consideration when they amount to inhuman and degrading treatment. And this means that very often there is a very high threshold of harm for non-refoulement to be triggered. So, and this is also, I think, related to the question that we had in the first session about how we can, well, in this case, it's about non-refoulement, but more broadly, how we can look at socioeconomic rights also in the context of other conventions. And I think that human rights bodies that have jurisdiction to decide on breaches of economic, social, and cultural rights, such as, for example, the Committee of the Rights of the Child, but also the Committee of the Rights of Persons with Disabilities, and of course the Committee on Economic, Social, and Cultural Rights can be new avenues somehow to litigate non-refoulement cases arising from socioeconomic harm, as this convention really recognizes the interdependence and the equal importance of civil, political, and economic and social rights. And the Committee on the Rights of the Child has very clearly made the point that the assessment of the risk of irreparable harm to the child upon return should take into account economic, social, and cultural rights. In particular, for example, the serious consequences for children of lack of food or lack of health services. Please. So the last case I'm going to present quickly, so so that Isabella will also have time to present her cases. It's another case of the Committee on the Rights of the Child, which among other things is looking at the best interests of the child in the context of deportation and return decisions. This case is about the intended deportation of a mother with 2 children to China, who are also rejected asylum seekers. The mother is claiming that in case of return to China, it would be difficult for her to register her children in the family household register because she's an unmarried mother. And the key issue here is that that the registration in this family household register basically is essential in China to ensure access to health, education, social services, and also it is the only means to prove one's identity. So it's considered essential for have access to many rights. This case, we can go to the next slide, please. It's important and interesting because in this decision, the committee recalls that the best interest of the child should be a primary consideration in all decisions that concern the deportation of a child. the committee held that Denmark, which is the state against which the case was presented, Denmark failed to duly consider the best interest of the child when assessing the risk of irreparable harm in case of return to China. And therefore, the committee found a violation of Article 3 of the Convention on the Rights of the Child, which is the article about the best interest of the child principle. Next slide, please. What I wanted to stress about this case is that the Committee on the Rights of the Child has been very clear that states have a duty to give primary consideration to the best interest of the child in all return decisions that directly but also indirectly affect a child. This case, for example, was about the deportation of the children with their families, but there are also other interesting cases about, for example, deportation of unaccompanied children, or also about deportation that somehow indirectly affect children. For example, there is the case that is mentioned in the slide, OM against Denmark, which is about the planned deportation and entry ban of a father that would result in the separation of this father from his children. And in all these cases, the Committee on the Rights of the Child found a violation of Article 3 because it found that states are failing to give primary consideration to the best interest of the child in deportation decisions. And something which I guess is somehow open for further litigation is also the possibility to use the best interest of the child as an independent source of protection from return, in the sense that the best interest of the child could also prescribe the removal of a child who is not entitled to protection as refugee, or also of protection according to the non-refoulement obligation in international human rights law. And with this, I conclude. Thanks a lot for your attention, and over to Isabella, who will present other 3 cases from the UN treaty bodies.
Thank you so much, Paula. Could we pass to the next slide? Thank you so much. So good morning, good afternoon, everyone. Indeed, I'm going to present 3 cases very, very briefly. All the 3 cases are decided by the Human Rights Committee, so I will just be referring to the committee or the covenant. So the first case is the climate change related harms, and the only case so far decided on this topic is the case from 2019, Teitiota versus New Zealand. And the case concerns removal of a nation of Kiribati back to Kiribati that who was rejected asylum seeker, which he challenged under the right to life because of the rise of sea level in Kiribati results in the scarcity of habitable space, which cause the land disputes and environmental degradation. We could pass to the next slide. Thank you. So on admissibility, the committee declares the case admissible because the author sufficiently demonstrated that the rise of sea level and degradation and the security and environmental situation in Kiribati indeed poses a potential threat to his right to life. On merits, however, the committee was not in a position to find that his right to life was violated. The committee highlights this principally for the organs of the state to conduct the evaluation of the claim and evidence, unless it can be established that there was a clear arbitrariness or manifest error injustice in the domestic authorities' assessment. And here the committee assesses specific claims and decides that this was not the case. So if it could not find the domestic authorities' assessment represented this arbitrariness or denial of justice. Let's pass to the next slide. Thank you. Although the committee did not decide in favor of Teitiota, the case nevertheless presents interesting point for establishing non-refoulement obligation in the context of climate change or more broadly in the context of socioeconomic deprivation. First of all, the committee establishes a link between climate change, the right to life, and non-refoulement obligation. The committee agrees that climate change and environmental degradation can pose a threat to the ability of people to enjoy their right to life, first of all. And secondly, the effects of climate change in receiving states can threaten the ability of people to enjoy the life to life, or can involve the issue on the prohibition of torture or treatment, and thereby triggering the non-refoulement obligation of sending states. Secondly, the standard of proof. So it's a question whether the risk should be imminent or only foreseeable. So although the committee explicitly refers still to imminency, which is difficult to prove, in fact, it examines foreseeability of the threat. And finally, the committee highlights that the right to life includes also the right of individuals to enjoy a life with dignity, which is, of course, also relevant to broader cases of socioeconomic deprivation. Thank you. Could we pass to the next slide? Very quickly on the family life. So the case which I really wanted to briefly look at with you is the DT case, DT versus Canada case from the 2016. It's a case on the potential separation of the returnee and her child who is allowed to remain in the host state. So the person who faces return is a single mother, rejected asylum seeker from Nigeria. And her son has already nationality of Canada and can stay there. And the son suffers from various medical conditions for which he is receiving educational and medical support in Canada. We could pass to the next slide. Thank you. So the case is analyzed, is assessed under various articles of the Covenant, especially Article 17 and 23 on the right to family life. And as in such cases, the committee conducts a two-step assessment. First of all, it needs to verify whether at all there was an interference with the family life. And secondly, whether this interference was arbitrary, because only arbitrary interference is prohibited under Article 17. So here is interesting. So just so we can maybe go already to the next slide for the sake of time. So this proportionality assessment assesses whether the potential return would produce an excessive hardship to the family and its members compared to the legitimate objective advanced by state. And here in this case, because the state party did not give sufficient weight to the best interest of the child, of the son of the applicant, the committee concludes that there was an interference, an arbitrary interference in the both family life. We can pass to the next slide. Thank you. So 3 key takeaways from the case. First of all, the committee decides that there was a violation of the right to family life, although the applicant state was not documented, was irregular in the host country. Secondly, the factors considered in this proportionality assessment. So here, the son help status was a key element, but in other cases, the committee looks at other elements, such as general integration of the child in host country and concomitant lack of links with the parents' country of origin. And third quick point, in such cases where we speak about potential separation of the child and the parents slated for removal, the CRC, the Committee on the Rights of the Child, can be an interesting avenue because of Article 9 of the Convention of the Rights of the Child, under which states should prevent separation of the child from his parents, his or her parents. Thank you. We can maybe also very quickly pass to the last point I wanted to look at. And next slide, which is the right to family/private life. And the case I wanted to quickly look at is the case Budlakoti versus Canada from 2018. And it's a case of a return, because of criminality this time, of an integrated migrant. So it's a case of a young adult. He was like 24 years at the time of his initial submission, who was born in Canada. His family lived there. He had a permanent resident status. And yet, because of the criminality, Canada tries to expel him. We can go to the next slide. Thank you. So the committee assesses the claim first under the right to family life, and it conducts a similar assessment that we just looked at previously under the DT versus Canada, meaning it checks, first of all, whether at all there was an interference, and here it concludes that indeed there was interference, and secondly, whether the interference was arbitrary, and here also it concludes that the interference was arbitrary. Again, weighting the state reasons for return, here it's criminality, a prevention of future commission of crimes, versus hardship that the return would cause to the person and the family. And this claim is also assessed under another article of the Covenant, which is Article 12, Paragraph 4, right to enter one's own country. And here, very interestingly, the committee considers that the Canada is Budlakoti's own country because of the strong ties connecting him to Canada, and interference with this right is also arbitrary, considering similar as elements as under his private life. We can pass to the next slide. So very, very briefly, 3 key takeaways from this case. So first of all, notion of private life is not mentioned at all by the committee, but its elements, which is broadly integration, are assessed, meaning protected under the notion of family life. Secondly, the right to enter one's own country offers an interesting parallel or alternative avenue to protect dwelling or integrated long-term migrants from return based on the understanding of one's own country as the strong ties between the person and the country, irrespective of any nationality, former nationality. And finally, the right to family/private life, or the right to enter one's own country, can offer a very interesting avenue for advocacy, for pathways, for regular stay for migrants, long-term migrants in an irregular situation who are well integrated, because from certain point of time, we can say that illegal administrative stay is irrelevant if the person is well integrated. Thank you very much for your attention. We are open to any questions or comments that you may have. Thank you.